It's my privilege to be the host or the first day of the National Conference, RAFT 2022. I'm Dr. Aarti, Assistant Professor from the Department of Forensic Medicine and Toxicology. I'll be the host of the session and a few housekeeping before we kickstart in. Kindly keep your videos on if whenever possible and keep your audios off. If there is any doubt, please do drop it in the chat box. And at the end of the sessions, we will make sure that our speakers do take up those questions. And for the information, the program is being recorded in the local device so that in case after editing, since it's forensic content, after editing sensitive issues and cases which are open, the videos will be provided in YouTube platform. We also request our speakers to raise objection if they are having contents which need not be shared in social platform, in which cases we will stop the recording immediately and we will go ahead with the program. So for the first session, it's a privilege again to welcome Dr. Mukesh Yadav on the topic Reformation in Criminal Justice System in India by amendments in Section 174 CrPC. Sir, a hot topic in your hot plate. To chair the session with us, we have with us Dr. Sampath Kumar, Professor, Forensic Medicine Department, Savita Medical College, and he's also an ex-vice principal of SRMC RC College, Chennai. Happy to have you, sir. And we also have Dr. Sarvesh Tandon, Professor and Head Forensic Medicine Technology, Safdarjung Hospital, BMRF Institution, New Delhi. Sir, happy to have you and see you again. Hi, sir. I request Dr. Sampath to introduce our speaker and Dr. Sarvesh Tandon at the end to give a summary and a closing remark. Thank you all. Sir, over to you, Dr. Sampath.
Thank you, Dr. Aarti. Are you able to hear me?
Yes, sir. Loud and clear.
Okay, thank you. Before proceeding with the speaker, my friend Dr. Mukesh Yadav, I just wanted to, first of all, it's my proud privilege to thank James Rajesh and Dr. Aarti, both of my friends, for giving me this opportunity to chair this first session on the first day. So, before proceeding, a few words about Dr. Rajesh, because I love to tell about him because he served as a role model in SRMC as long as I was there for 32 years. And now it is being headed by Dr. Pradhan. He was not only a gold medal winner during his MD forensic days, but he was one of the candidates who was selected among the clinicians to be awarded the MD ICMR training program. So MD PhD training program, he was awarded, and he continued and almost completed it for 3 years. But fortunately or unfortunately, he had to leave to France because of his compulsion from his family. And then he set an example by returning the 10 lakhs rupees he received for just for this research work to the ICMR. I think he was one of the only candidate, at least in the southern part, to return the money for not having completed. And not only that, he was an excellent set an example for other PGs in his medical legal work, especially during the second autopsy and during exhumations. So I just wanted to thank him and be an example as an role model for the youngsters. And then to thank Aarti and his entire team for conducting this national conference in spite of the initial setback due to the pandemic. Your university has been kind enough to support you in the future endeavors. Regarding this reformation and advancement of forensic medicine and toxicology, along with the Medical Legal Association of Pondicherry, the entire Tamil Nadu Medical Legal Society is behind you and Dr. Rajesh, so that we will extend whatever information you need on your state I also welcome the co-chairperson, Dr. Suresh Tandon, professor and head of forensic medicine and toxicology, AMC Safdarjung Hospital, New Delhi, and the other speakers, eminent speakers who has been chosen just to be congratulated. The following the sessions, Dr. O.P. Murthy, Nagi Reddy, Siriak Jao, and from your college, there is another medical superintendent, JC happens to be my another close friend. And coming to Dr. Mukesh Yadav, just a few seconds, because you have already introduced him to the entire audience. He was an young, handsome gentleman, as far as I know, with a clean-shaven face. But now with beard and other things, he looks more like a scientific person, as a scientist. So it is my proud privilege to introduce a true academician. He is a true academician. In fact, he did his BSc, followed by MBBS and MD Forensic Medicine, and then PG in Human Rights, and then he did an MBA in Hospital Administration, and he did a law LLB, and then he also completed his PG diploma in healthcare and hospital administration, an excellent person to be a COO of any hospital. He has got 26 years of vast experience in various capacities, in various places, including Madura, Farzabad, Kapur, Mainpuri, Mordabad, and Greater Noida. So I welcome him to deliver his excellent address, and he has got about 100 publications in hand, and he has written a number of topics on various books, and he is an editor-in-chief of the Indian Indirect Journal and editor of Journal of Indian Academy of Forensic Medicine, apart from now continuing to be the General Secretary of Indian Academy of Forensic Medicine and hosting the next coming National Conference of Indian Academy of Forensic Medicine in Lucknow. I wish him all success for this upcoming national conference, in spite of all the hardships he has faced by changing the venue and the dates. Still, we will gather in large numbers to support him. Regarding his topic of reformation in criminal justice system in India, in fact, that is an it is an investigation into the facts of the sudden death. If the investigation is done properly, there are many re-investigation by other agencies could be avoided. A simple unnatural death can become a sensitive issue. We have seen in various cases, even recently regarding the religion. So anything can turn into a sensitive issue later on. So as far as section, we will have to be very broad, so that the innocent is being protected, at the same time the criminal is being convicted. So that will help the moral fabric of not only our government but the entire India in the investigations. So yes, I know that we will protect the fabric of our country by suggesting the latest amendments which has been introduced and to be introduced, as he's a great thinker. I wish him all the best. Thank you very much for giving me this excellent opportunity.
Thank you, sir. Sir, over to you, Dr. Mukesh.
Thank you. Am I audible?
Yes, sir, you're audible.
First of all, with the permission of Chairperson Dr. Sampath Kumar and Dr. Sarvesh Tandon, I will start this guest lecture, very pertinent in relation to theme finalized by the organizing team and in relation to current context of the India, when we are facing economic crisis and due to that COVID-19. And in spite of that, now we are coming out of that crisis. And in this crisis, role of criminal justice system is very relevant. And when we talk about the criminal justice system, we cannot forget the role played by our forensic fraternity or our subject forensic medicine. Our all organization, including Indian Academy of Forensic Medicine at the national level and the local state chapters like Medico Legal Association of Pondicherry and the state chapter of IFM, they are also playing their great role in providing this proper quality medical evidence so that others can get benefit and innocent can be acquitted and the perpetrator of crime should be punished, and that too in timely manner. Because here, when delay justice is popularly known as denial of justice. So here our role is very relevant. So with this theme, I again congratulate Dr. Rajesh J. James and Dr. Aarti and whole team and the institutional pattern who has given you this opportunity to organize a national conference on the recent reformation in criminal justice and toxicology. So again, we have done a lot of work on this topic which is assigned to me. I'm just refreshing some of the silent points so that within that time frame allotted to me, I will be able to make a justice, especially to the young potential, these virtual delegates who can get benefited. My assurance to all the new generation, the future of forensic fraternity or those who have opted this as a career is very bright and great. The thing which you remember, never make yourself static. Never go into a comfortable zone. Always try to contribute whatever your resources, whatever effort you can do to the upliftment of the whole forensic subject or the topic which you have chosen to work especially on that forensic sub-specialty. Both speakers are my esteemed seniors, especially Dr. Sarvesh Tandon, who is my contemporary, just I think 6 months senior to me from UP. Again, I thank Dr. Sarvesh to be chairperson of this session, and Dr. Sampat Kumar always loved me and always offer me whenever I need his help. To begin with, word over, there are two types of criminal justice system, which is again usually not part of our textbook. These two systems are popularly known as adversarial, this criminal justice system, or inquisitorial criminal justice system. Although it is not part of any statute or constitution of India, but when we go to various pronouncement of the Honorable Supreme Court or various high courts or the judgment of abroad countries, landmark apex bodies, you come to know these two systems. And both system has their advantage and disadvantage. In this adversarial system, there are two parties to the conflict, whether civil or criminal, and there is a one judge which is sitting, listening both the party, taking and their whatever evidence they are producing in their favor to prove their case. And in adversarial system, he is playing as a neutral role. And finally, after completion of the whole trial, he pronounced the verdict. So, and in contrast to that, in investigatorial or inquisitorial, this criminal justice system, where judge play a proactive role, he can anytime suggest any party to produce this evidence. So, this is some of the basic differences. But recently, I gone many judgment of the Honorable Supreme Court, where this inquisitorial criminal justice approach adopted by the Honorable Supreme Court to pronounce the judgment or to give justice. The whole purpose of the criminal justice system is to find the truth and to deliver the justice. In common vocabulary, both terms, truth and justice, are used synonymously, and they are after part of that becoming the judgment, and which is result of a long trial, especially in India, where a case, especially criminal, when finalized at the apex court level, may take 10 years, 20 years, 30 years. So this is again area of concern for amendment, how we can enhance or speed up the trial, especially criminal trial. Whenever there is a crime, it is reported to the police, so police come into picture. So in this whole criminal justice system, court is there, which is headed by the judges. Police is there, who is playing their role in investigation, and we as a forensic fraternity are part of investigation. So please, all young faculty, just remember, we are not directly in picture, but we are part and parcel of this whole criminal justice system. Actual beneficiary of our services is the police department or home department, and we are employee of the this health department or medical education department. In many states, including UP, the whole this health department again divided into two ministries: health services and medical education. And to understand very well, because when you go to the definition of the forensic medicine, it is the application of medical knowledge, scientific knowledge to aid in the administration of justice, and this is the actual aim of the criminal justice system. Here our knowledge to help judges to understand not only the medical part but the legal part also, because medical jurisprudence says legal aspect of the medical practice. In any civilized world like our, which is governed by the Constitution of India, we must have a fair knowledge of the Constitution of India, especially Chapter 3 and Chapter 4. Chapter 3 deals with the fundamental rights of every citizen in India. And out of those fundamental rights, Article 21 is the most relevant article, which deals with the right to life with liberty and dignity. And the scope of this Article 21 enormously expanded by various pronouncement of the Honorable Supreme Court judgment, which is law of the land in the form of case law. So we have basically three types of law which we are dealing with. One is originally originated from Constitution of India. Next, law enacted either by the Parliament, that means central government, or by the state government. To understand this technicality, because this is the basic crux of understanding the whole concept of this forensic medicine or legal medicine, because forensic medicine is the sister concern of both law and medicine. So we must know both things, and that is why the whole other clinical department, they are looking towards the forensic medicine for help whenever they face any medico-legal problem, including cases of medical negligence or death due to alleged criminal medical negligence. Here our role as a forensic torchbearer to help our other faculty or medical fraternity as well as the general public, so that the faith or trust in the medical profession remain intact and nobility of profession cannot be doubted or challenged due to many lacuna in the system. So from that point of view, post-mortem is usually asked by the police, and that too under this section 174 CrPC by investigating officer. Again, the practice is very well different in different part of the country, including Union Territory like Pondicherry, it may be different. Like in the states of South India or North India or East India or West India, they may be different because there are many resource constraints in the form of infrastructure as well as the qualified or quality manpower in the form of, say for example, post-mortem work in most of the part of India is done by not forensic medicine expert, but simple plain MBBS or even specialist of clinical department. And whenever they commit mistake, usually I have many case law, I will discuss those case law in this presentation, where court has emphasized the need to be post-mortem conducted by forensic medicine expert only. But again, there is a big constraint availability of qualified forensic medicine expert throughout the India. I'm giving just one example. Recently, after a lot of effort by Indian Academy of Forensic Medicine as a national organization, as well individual efforts by many forensic fraternity to bring or enforce guidelines by the central government to appoint one forensic medicine expert as a specialist in every district, especially of UP, and 75 posts of permanent forensic expert has been sanctioned, and they have been advertised by the UP Public Service Commission recently 2 months before, and only 25% specialists appear for the interview, and out of those 25 selected, only 22 join. So this is the point which we must keep in mind, why there is a need for other specialist or plain MBBS doctor to involve in our post-mortem work or medical legal work. Here, as a stopgap arrangement or to implement the whole amendment which suggested by a committee of IFM, we should provide a proper training, not only to the medical officer involved in post-mortem examination, till actual forensic medicine experts are available. Here, my request to all the senior listening this virtual conference, start PG courses in your department, if not started. If started, please enhance the capacity of seats of MD so the new generation of MBBS doctor can join your specialty. Again, motivate them and show them the way, what is the future of forensic medicine in country, as a teacher, as a medical legal expert, as a specialist, and also even there is a scope for private practice of medical legal issues. I am giving many opinion free of cost. So I am knowing that there is enormous potential for forensic fraternity. This is for young generation to remember. Now come to the next point, medical evidence and opinion. There are certain limitations which we must know as a forensic fraternity, because emotionally, when we are involved in medical legal work, we usually expect that whatever opinion has been given by us, it will be accepted by the court of law. But the picture is not there. Why? Because there is a limitation. When you go by the legal aspect of Indian Evidence Act, acceptability of evidence by a court of law. So there are two types of evidence, direct evidence or indirect evidence or opinion evidence. Ours is a opinion evidence. Direct evidence is in the form of eyewitnesses. So suppose there is an eyewitness to any crime and he is saying the patient has died due to that use of weapon, say for example, a blunt weapon. And you are giving in your opinion, either in injury report or the post-mortem report, that the weapon injury caused by a sharp weapon. So there is a conflict in the opinion given by the eyewitness and opinion given by the doctor involved in post-mortem work. Here court, depending upon the holistic approach of the all evidences and statement of witnesses, they may ignore your opinion, and here we should not feel frustrated, because this is the requirement of the law throughout the world. There are limitations. Acquittal and conviction, this is the whole crux of the whole criminal justice system. If a person is innocent, he must be acquitted, and if a person is a perpetrator of the crime, he must be convicted, and that depends upon the quality of evidence produced by the persons involved in medical legal work. That means quality personnel involved in this investigation process, including police officers. Here, why we are crying for this amendment? Because since inception or enactment of this law in 1973, after Law Commission recommendation in 1955, we adopted the law which was embodied by the Britishers. We were ruled by the Britishers, so most of the law we taken from those rural or British India. So we have, at that time, there was many things which are not part of India. Say, for example, technology was not advanced. Forensic medicine may not be a separate branch in all medical colleges. Similarly, this police department was not having technology. DNA technology was not there. So many changes has been occurred with the passage of time. Now there is a need to include this technology, take advantage of this technology to be part of your medico-legal work. This is our one of the requests in suggesting a recommendation. We must have fair idea of law, constitution, and various case law pronounced by the Honorable Supreme Court or High Court under Article 226 and PIL by Supreme Court under Article 32. So these basic article we must remember, because most of the reform in forensic medicine are done through public interest litigations, either filed before the Supreme Court of India or in different high court. Depending upon the jurisdiction, you must know where one has to file PIL, because this is again basic crux of reform. We cannot sit idle just to look after the politician, because many of the pronouncement as well as a law commission report has clearly mentioned there is a nexus between the politician, bureaucrats and the criminal. So they are not interested in amendment of the law because they cannot be punished in swiftly or in fast track court. You remember this, all the amendment in the rape cases, rape definition after 2009 and 2016 amendment, after that Nirbhaya. But is there outcome of that amendment? Not. Why? Because the whole system is not used to that amendment. Even many investigators or judges are not aware of POXA. What to talk about the whole act. So here our role to provide this awareness and legal guidance to not only judges but the public prosecutors, police investigators and their senior bosses, so that they will be sensitized about our role. In many of our national conferences, I found one of the aspects, there is a lot of confusion about forensic science and forensic medicine. Most of the judges use the term forensic science, although broadly forensic science is a generic term which includes forensic medicine also. But in India, forensic medicine is usually in these are produced by the medical education department, medical colleges, while the forensic science person, they are having basic science knowledge or BSc science or MSc forensic science. So there is a difference between both and domain of work is different. We are dealing with human body. Forensic scientist deals after collection of that evidence from human body and handing over to the those forensic scientists. So this clear-cut demarcation must be known to us, and we will in all conferences try to. They are part of our team, forensic science. So we should not discriminate. We should realize their importance, but we should realize our importance also. That we are nowhere less than, because if we will not provide a proper sample of DNA or for any viscera, then they are not able to give a proper chemical analysis or DNA profile. So now coming to the quality of justice, depend upon the quality of evidence, and quality of evidence depends upon the quality of persons involved in the investigation, including police personnel at police level and the forensic expert, or including medical officers or for specialists involving in this medico-legal work. There are a lot of lapses in the existing criminal justice system recognized by the Law Commission of India. And if you go by the Law Commission report 206, which is submitted to Government of India in 2008, after a PIL filed before the Delhi High Court, where a person died outside India in Singapore, where already one post-mortem done, but the father was not satisfied with the post-mortem done in Singapore. He brought that body to the India and requested for second post-mortem. And at that time, this legal problem arose, and there was, since 1999, you are aware, Coroner Act was abolished in all part of India, including Mumbai, which was the last place, jurisdiction where coroner system was acting. So there is no provision in section 174 or 176 to perform post-mortem, second post-mortem for a death which is already occurred outside territory of India, outside India. That is why this PIL brought before the Delhi High Court, and on the direction of the Delhi High Court, this law commission has been requested to look after the feasibility of Coroner Act similar to Act in the UK to be implemented or enacted in India. Now, I will again emphasize this quote. Everything has been already said, but as no one listened, we must always begin again. This is said by Andre Gide, French thinker and writer. Whatever I am saying, whatever you are listening, that may be in your knowledge, that voice you have raised, that voice may be raised by many other persons not sitting in this virtual conference, but nobody realized the importance, because at that time, the time was not ripe to make these reforms. That is why again and again we have to raise our voice for general public interest. So I will like to quote from one of the Honorable Supreme Court judgment delivered in 2014 regarding relevance of this information. So what the Honorable Supreme Court in paragraph 28 said, criminal justice system in India is at crossroad. So whatever I am saying, whatever you are listening is said by the Honorable Supreme Court, not only in this judgment, but many other judgments. And he emphasized this importance of investigation, quality investigation, to improve the quality investigation by utilizing the technology. You remember the case of that where a advocate lady was killed by his paramour in Delhi, and at that time DNA was just beginning in India. Only in Hyderabad it was done, and that case by DNA technology and circumstantial evidence proved against that perpetrator, and court has quoted the use of DNA, because under section 53 or wherever examination is defined, or under Indian Evidence Act, nowhere DNA word was used, and that is why it was challenged. It cannot be taken as legally acceptable evidence. Here importance of reform is there. Here periodic review of all the law which are dealing with medical legal work or criminal justice system is important. Court on many occasions emphasize the relevance of expert scientific evidence. We have to define in law, in all the statute existing and in the future, to define everything. Nowhere we found the word post-mortem examination. Can you imagine, after more than 75 years of independence, we are not able to put this word autopsy or post-mortem in any of the statute or act dealing with the this criminal justice system, either IPC, CrPC, or the Indian Evidence Act. That is why there is a need for innovation and creative method as endorsed by the Honorable Supreme Court. There is necessity to strengthen the acceptance of science in crime detection. Even recently, in 2021, in a suo motu writ petition by the Honorable Supreme Court in one of the criminal case, emphasized the importance of uniformity in medico-legal system work throughout India. Because when the case comes to the Supreme Court, which is only one in whole India, from any part of the India, where practice of this post-mortem pro forma or post-mortem work or giving opinion, that format is different in different part of world. And judges which are sitting in apex court not able to understand that due to different diversity in doing that medical legal work. So they recently in 2021, I will show in one of the slides, importance of uniform this protocol for the medico legal work. Court again emphasized the person with opinion are gathered from the persons with knowledge in technical, specialized knowledge, whose skills and experience should be taken into consideration. Their education should be taken into consideration before determining any evidence or fact in that particular case. So if a court is saying something, and that too under Article 142 of the Indian Constitution, which is for filling the gap till Parliament or the state legislature pass the law, that becomes the law of the land. You remember the Jacob Matthew case of 2005, which deals with the alleged death of the criminal negligence and how a doctor can be prosecuted, how a postmortem can be done. And those guidelines of 2005 till not become part of the statute or this CrPC 174. That is why there is a need for amendment in the existing CrPC 174 and related act. You have to understand this technicality of the reform. The whole these legal matters, they have been divided by the Constitution of India into 3 broad categories under Schedule 7 of the Indian Constitution. These broad categories are: first, List 1 or Union list; second is List 2 or the state list; and third one is List 3 or concurrent list. And every list has n number of entries or serial number, which found certain specific area of law where who can make that law or enact that law. So specifically these entries 64, 65 and 66, they are relevant to this topic which I am discussing before you. Similarly, List 2, where entry number 1 and 2 are important. Entry number 1 deals with the police and law and order, and similarly entry 2. And here police, when this entry 2 comes into picture, your role as investigator come into picture, and your role as a part of that investigation team come into picture. So there is a conflict. Suppose central government is of another party and the state government is of another party, usually there is a dragging on any legal matter. So here importance of coordination between central government and the state government is important. That is why concurrent list is come into picture, or list 3 is there, where entry 1, 2, 11 and so on also mention about the role of both central government and the state government in making any enactment either in parliament or the state. Say for example, in our case, medical education is part of the concurrent list after amendment in the Constitution of India. Initially, it was part of the state list. So any state can start any medical college or any course previously before amendment. But after this amendment, when the medical education become part of concurrent list, that means in medical education, you remember the our apex body for controlling all the standard is previously Medical Council of India, now National Medical Commission. And National Medical Commission has been constituted under the National Commission Act 2019. Suppose state government make any law related to medical education and there is a conflict between the law made by the parliament and the law made by the state. It is as per Constitution, always the law made by the central government prevail over the law made by the state. That is why there is a problem of recognition of degree. Since I face this problem of recognition of my degree from state of UP from a government medical college, and I have to approach the Supreme Court, I filed a PIL, public interest litigation, and ultimately I got my degree in 1998. A degree was started in 1976 in my medical college at Kanpur. But my degree was recognized in 2014. Can you imagine the trauma, mental trauma faced by me or the similar candidate who are possessing government degree awarded by a statutory university enacted by the Central Act, UGC Act. But the degree was not recognized. Why? Because this conflict, you have to understand this technicality of union list, state list, and concurrent. Health services are part of state this list, while the medical education is concurrent list. So suppose we are doing post-mortem in medical college, so there is again conflict, because that law and order is state list. So law made by the law department, and they are not taking consultation with the medical education or forensic medicine expert or other professional bodies like state chapter or national body. There is always chances of conflict, and that lead to acquittal, that lead to decrease in conviction rate, because when there is any deviation of law of enacted act, court is not going to accept. Law and order is another state subject, so that is why there is a need for answering these questions. What are these questions I am putting before you? I am putting these questions to you. Give answer, because in the last slide I will suggest you a strategy for reform, and that strategy is multifaceted, multi-level. One is group level or professional association level, like Indian Academy of Forensic Medicine. Your Medical Legal Association of Pondicherry may play their role, state chapter may play their role, and individual efforts. So if you are aware, you are convinced after this lecture, you can make your individual effort as an individual by making your complaint or suggestion to the competent authority. Say, for example, we have suggested CP Gram, a portal of personal and grievance redressal Ministry of the Government of India, online portal where you can put this grievance that can be taken care by the central government and the competent authority. So you can not only part of IFM or your professional association at state level, play a great role in reformation and amendment, but also at your individual affair. I am giving one example in this regard regarding Dr. Indrajit Khandekar, a very well-known proactive our forensic fraternity, who is part of IFM committee, who has submitted these recommendations as a coordinator. He filed a PIL before the Honorable Bombay High Court on this issue. And after that issue, many things start moving. And in the last disposal of that PIL, court directed the state government to form a committee and submit recommendation, including recommendation of Dr. Indrajit Khandekar. And that they will be sent to the central government or the state government, if possible, to amend the CrPC 174. So this is one of the great example of the individual effort made by one of the faculty of forensic medicine. What are the second question? What are the older methods followed in India and world over? So you are knowing in your textbook or forensic curriculum, there are basically three types of system. Medical legal examiner system, supposed to be the best system in the world over. Because it is headed by a forensic medicine expert, whether you call it forensic pathologist or a police surgeon or by whatever name. So it is not the name, but the team members and the leader of that team that will decide the quality of investigation and quality of evidence. Here our role to cry for part of the investigation team is important. Other investigations of what is prevalent in India in currently after abolition of coroner system in 1999 is police inquest or magistrate inquest in very few cases, and judicial inquest in under article section 176 CrPC. Now, third question, why this police inquest was brought to India? Answer is simple. We were governed by the Britisher at that time, and that is the law adopted by us or enacted by the parliament or the state legislature, and that is prevalent till date, till we make amendment to that. Why this police inquest was brought? The same answer. Which is the best method? I have already told. The method best depending upon who will lead the investigation team. It may be police officer if it is qualified, properly trained by the forensic person, or a forensic specialist heading that team, especially at the time of scene of crime. Visit of the scene of crime is very important for the success or failure of any case during trial, either acquittal or conviction. Next question, what is the procedure to change the existing system? I have made a background to you regarding constitutional provision. I have made a background regarding 3 lists or 3 schedule of under schedule 7, union list, state list and concurrent list. There is overlapping of these things. Say for example, investigation is part of union list, and that is why police training center, they are opened by the central government. Recently in UP and Ahmedabad, Gujarat, Forensic Science University has been established by the central government under the union list. So we have to understand, we have to approach individually as well as part of Indian Academy of Forensic Medicine and state chapter to bring change in the amendment. What is the role of forensic medicine expert in new curriculum? Competency-based medical education is implemented now in India after this National Medical Commission. So our subject is now getting more important. Now it is gone to the pre-final year or third professional. Because we have made recommendation in previous IFM deliberations and conferences to broad changes in this curriculum. Because when the student come into the clinical department, they actually realize the importance of our subject. Medical negligence, consent, medical record keeping, anything, any new law, organ transplantation, everything is successfully enacted, implemented only with the help of your teaching in a medical college as a forensic fraternity. Now, what effort has been done by the Indian Academy of Forensic Medicine? Since the tenure I have took as the General Secretary, we started deliberating on this issue of reform. So in 43rd Annual National Conference, we purposely kept this theme, reforms in criminal justice system of India, role of IFM in policy making and implementation, just to sensitize everybody who is seeing our brochure, visiting our website, whenever we talk about the guest speaker, chairperson, so that emphasizing this importance of amendment by all. A 5-member committee has been formed after the resolution passed by the Executive Committee in its meeting on 22nd June 2029, approved by the General Body in its meeting 31st January 2020, and finally recommendation was submitted after suggestion asked by the 5-member committee under the coordinator Dr. Indrajit Khandekar and Chairman Dr. Pankaj Gupta, and 1 member from each zone. We make 1 member from each zone, and that to a learned member who had devoted a lot of time. So this link is there. I'm again requesting to all the listener, please visit our website of Indian Academy of Forensic Medicine or click this link to get the whole comprehensive document on recommendation regarding amendment in the criminal justice system through amendment in section 174 CrPC. These were our learned member who has done a lot of deliberation almost for 1 year and then submitted this recommendation. I thank all these members. The main questions which was framed by these committee member and asked through different media, maybe online or Google form. First question was, who should carry out the post-mortem examination at district and rural hospital? You know, these post-mortem can be done at any level, maybe at PSC, maybe at CSC, district hospital or medical college level, or institution of national importance like AIMS, Sanjay Gandhi, Lucknow, or PGI Chandigarh, etc., etc. Even Pondicherry, Autonomous Institute. So who will conduct these post-mortem? This is the question we have to answer. Maximum reply are in favor of including a pronouncement of the Supreme Court regarding it should be done by the forensic medicine expert or Still, there is a shortage of forensic medicine expert by a specially trained medical officer by the forensic medicine expert. So this may be taken into consideration to give a stopgap arrangement. This provision of amendment must keep in phased-wise manner, because once it becomes law, then it is very difficult to implement if there is no enough forensic medicine expert available in district level or rural, this CSC or district hospital level. And that is why central government recommended one forensic medicine expert at least to begin with at every district. At least in UP, this has been started, and we are trying to put one forensic medicine expert in addition to medical college faculty. Again, central government move, which is important for you as a career opportunity, as well as in this amendment. Central government has planned in consultation with the state government to open one medical college in each district. UP has taken lead. We are almost covered 65 districts till date to open or in the process of opening medical college. That means you are having out of 75 in 65 districts, one forensic medicine expert, minimum one. Otherwise, in a forensic medicine department of 100 admission, 3 forensic medicine expert as faculty, 1 assistant professor, associate professor, and professor. If PG is there, so that is additional. I am giving example of my medical college. Mine is a new medical college, and we got recognition that too for 1 year for MBBS this year. And I have vision. I have planned since I joined this medical college to start PG in forensic medicine. I applied for that, and I got 3 PG seats in a small tenure. So this is an example. If you want any help from IFM, from me, our other senior faculty member, how to increase forensic seats in your medical college, because quality depends on number of person and number of postmortem. If you are overworked, if you are attending court duty, if you are taking classes, you cannot do justice with the medical legal work. So there must be enough number of forensic medicine expert available. Till that time, we rely on training. So training should be part of our strategy in reform, either sending these recommendations to the government of India, state government or police department. So not only training with the police officer, we have started in our district. Similarly, who should assist the doctor conducting the post-mortem examination? I not found anywhere. If you have, please share with me. Is there any technical program, technician program conducted any part of India where post-mortem technician is there? Is there any course, diploma or certificate or even skill development course? I think no. So if, say for example, a doctor is doing operation in operation theater and there is no trained OT technician or staff nurse, do you think the doctor is able to do justice? So why there is a discrimination in dealing with the dignity of the dead? Article 21, Supreme Court of India and various High Court pronouncement clearly expanded the definition and scope of Article 21, where they said dignity of dead is important, equally important as dignity of a live body. And that is why these suo motu cognizance taken by Honorable Supreme Court and High Court, including in UPA, ongoing PIL on this issue. I will share those PIL. So those who are interested in either in your territory, this union territory or state, they can take initiative through state chapter or help of Indian Academy to file PIL or a common PIL in the Supreme Court to improve or reform in this medical legal work. Who should do the postmortem examination of dead body of a female? If you remember this 2009 amendment, medical examination of rape victim will be done by lady medical officer. So can that be applicable to dead body of female in postmortem also? Again, debatable. Again, depending upon resources. But if possible, if female forensic fraternity is available, they should be preferably done or under their supervision, so that dignity or privacy of female dead body can be maintained under Article 21 of the Indian Constitution. Next question, who should make rules for post-mortem examination, whether it is the central government or the state government or the both? And I am again adding one more, whether the Supreme Court of India under Article 142 or High Court of the state. I have given example of all the three lists of Schedule 7, union list, state list and concurrent list. So all three are important to make these amendment or changes. And recently in suo moto PIL, Honorable Supreme Court notified, I will share that document also with you, a protocol, uniform protocol throughout India for criminal, medico legal work, and chapter 1 deals with your part, including Panchanama, including crime scene visit, including that post-mortem report or injury report supported by a body sketch diagram, so that judges can easily understood the area where you have described that particular injury. So answer to all these questions I have given. Last one, any other matter? This was the open question asked by all experts by this committee, so that anything which is lacking in these previous 5 questions can be put as a additional suggestion, so that that will be part of this recommendation. I am just not giving much time. I have already discussed about different type of these inquests. I will quote here one very popular quote: old wine in new bottle. We should not go for that. कि नया कानून तो आ जाए, where there is a amended law or statute, but there should not be address of advancement in technology. Say for example, virtual autopsy. Say for example, role of CT scan or MRI in autopsy, non-invasive autopsy, DNA technology, etc., etc. They should be part of new law whenever there is a enactment. And as a comparative study done by our committee, they recommended medical examiner system existing in USA is the best method, because that is headed by the forensic fraternity. This is again regarding Coroner Act. After 2008, judgment delivered by the Honorable Delhi High Court on 12th October 2007. On that direction, Law Commission has been framed, which submitted report in number 2006 in 206 in 2008 regarding enactment of Coroner Act similar to Coroner Act 1988 of the UK. But since that submission in 2008, now we are in 2022, nothing has been done by either the central government or the state government or any local government or Panchayat Raj institution. So proposal of this enactment of new Coroner Act is still pending. The recommendation, hard work of Law Commission of India, not getting that see the light of the parliament of both houses. And here this Law Commission again mentioned regarding the importance of Article 21, the enormously expanded scope of Article 21 of the Constitution. Right to know the cause of death is the fundamental right of the family of the victim. Right to know the quality of judgment in their favor if they are victim is part of Article 21. Not only victim, right to speedy trial accepted by Honorable Supreme Court, endorsed by Honorable Supreme Court on many occasions, is a fundamental right of the accused under Article 21. Why? Suppose an innocent person is framed and the judgment taking 20 years or 30 years in pronouncement, final pronouncement, that is not injustice to that accused, which is not actual accused as per the fact and circumstances of the case. To inquire into the true and real cause of death of a person, even if such person dies outside the territory of the country. So if any, because this is a era of globalization, multinational companies are coming to our country. Our person, qualified person, they are going in other country for their job or career options. Suppose death occurs there and they want post-mortem in our country at their motherland. There is no provision till date, in spite of Honorable High Court judgment, in spite of Law Commission clear-cut recommendation in the form of draft will of Coroner Act 2008. You must go through that act. And court has also mentioned one of the judgment in this case. The purpose of underlying an inquest is to explain in following word. An inquest is fact-finding inquiry, because we are part of inquest in the form of post-mortem examination conducted by a coroner with or without a jury to establish reliable answer to 4 important questions. We all know what are these questions. One is regarding identity of the disease. Next is regarding the place of the death, that is where scene crime visit is important. And the third is time since death, which is important. And fourth one is the most relevant and most important, cause of death, whether that is a natural cause or unnatural. If unnatural, whether it is homicide, suicide, or accidental death. Here, whole judiciary, whole investigating team depends upon you, forensic fraternity, medical fraternity. So there is no doubt regarding that need for this reform. And finally, Division Bench of Honorable Supreme Court in a recent judgment headed by Chief Justice Bobde and Dr. Justice L. Nageswar Rao. And the last highlighted portion you just read, this court may also consider issuance of direction under Article 142 of the Constitution to fill the gap if there is no law enacted by central government or the state government in this medico-legal or criminal justice system reform. So this is the fourth option. We can file PIL with all the literature, case law, so that this process of amendment can be expedited. Under that, again, I'm again quoting this, the recent judgment, which is ongoing PIL by suo motu cognizance by the Honorable Supreme Court regarding need for uniformity. Dr. C.V. Jani is addressing, I think, on the second day on this topic of need for uniform medico-legal protocol. Court has mentioned 2 states criminal this protocol, like Kerala criminal protocol practice of 1982, where rule 42 marking of exhibit and point number 9 mentioned the healthy practice in some of the state, and including wound certificate, post-mortem, to make that body sketch diagram mandatory part of that medico-legal report, so that doctor who are not familiar with the anatomy or medical terminology used in our report, they can very well understand whether the injury involving vital organ or not, whether injury involving non-vital organ, etc. So this, based upon this judgment and these findings, this is the link of this judgment, where I found this criminal uniform protocol of criminal, this medico-legal work directed by the Honorable Supreme Court to all the state government chief secretary. And recently, I found notification from the state of Madhya Pradesh. They took cognizance, they shown sensitivity on this issue and notified to all the concerned involved in medico-legal work कि mandatory fill these pro forma, attach this body diagram in front view, lateral view and back view to mark these injury either in post-mortem report or in the wound certificate. If you remember, few of those who are maybe part of this conference, in 2009, there was a move to brought a bill on forensic science services, which was later on changed the title Forensic Regulatory and Development Authority of India Bill 2011, available online. But again, we are in 2022, 11 years has left. This bill has not seen the ray of light in any parliament. These are some of the definitions used in that bill. Again, one of the case law, I'm quoting from the Allahabad High Court. Status of mortuary, because this is another question in your mind. Whether mortuary should be well equipped, whether it should be as per the Medical Council of India or Government of India norms or not. So this is the judgment of Muhammad Qasim versus State of USP, and a series of direction has been issued by the Honorable Allahabad High Court, and based upon which, what was the impact? One of the judgment I am citing from that judgment. Division bench was informed about the development taken place in pursuance of the earlier order in the same case by the Allahabad High Court, and these 7 points taken as action taken report submitted before the Honorable High Court by the Home Ministry, Health Ministry in a affidavit, and those points are need for training of medical officer in forensic work, need for improvement of mortuaries which are not well equipped or not having enough space, and whatever the area recommended by the Medical Council or National Medical Commission. Sanction of post, they address the issue of manpower in the existing lab and need for opening one forensic science laboratory in each district, until it is not possible, mobile forensic van in each district, so that scene crime can be covered in a short time by using that mobile van with expertise available with this forensic unit at district level. Finalization of pro forma for PM report. Court has said there is a not uniformity in pro forma used by the doctor in doing postmortem. They were not satisfied with the quality of the paper used for postmortem, and court specifically made a scathing remark that when this case comes to the High Court or Supreme Court in appeal, the quality of paper on which postmortem report has been written is totally destroyed, illegible, not able to be preserved, because the quality of paper used for postmortem report of not good quality. Then upgradation of SSL and existing lab, and now there are almost 4 functional lab in 4 regions of UP after this direction. Disposal of old sample viscera collected in district. This was a very great problem faced by the forensic fraternity or medical fraternity involved in this postmortem work, especially in poisoning cases where viscera has to be preserved and sent to the chemical analysis. They were lying in the mortuary itself for years together. Maggots are developed, destroyed totally, not relevant for further analysis, but there was no law how to dispose these viscera lying in the mortuary, giving a foul smell and not a atmosphere to work in the mortuary. And after this direction, these viscera has been disposed in through incinerators available in a biomedical manner, a biomedical family manner. Meeting of the state level committee. On the direction of the Honorable Court in this PIL, 3-tier committee has been constituted. One at the state level, another at the commissionary level, and third one at the district level, where judges are the part of that committee. Principal secretary of all the ministry are part of that secretary. Principal and Director General Medical Education and Health Services are part of that committee. Then police, superintendent of police, they are part of the, so all the stakeholders made part of the committee, and there are direction, there should be periodic meeting of these committee to suggest improvement in the quality medico-legal work and action taken on these 7 recommendations. Now, need for skill trained manpower, I think there is no need to devote much time. I have already emphasized on, till we are having enough number of qualified MD forensic medicine, we should concentrate on the training module. I have requested my team of IFM that we should start training module or training courses for those medical officers, those who are interested or already involved at district level or CSC level in medical legal work. So mandatorily they should go at least of 6-month training, or preferably 2 years in form of diploma or MD. There may be chances of weightage given to them in NEET examination so that they can do MD forensic medicine to fill that gap, because the quality of postmortem work is not possible without availability of adequate trained forensic medicine expert. Pathetic condition of mortuary, this is the comment by the Honorable Supreme Court. And on that direction, again, an example of a success story from PIL. 18 district mortuary. Yes, anything?
Dr. Mukesh, just a gentle
time
regarding the
okay, I will just finish quickly. So these are the 18 mortuary where 8 crore 68 lakh money has been allocated, and these mortuaries are now improved as modern state of art mortuaries, and rest are under process. Similarly, this recent advertisement from UP Public Service Commission of 70 posts of forensic medicine expert, I am requesting all forensic fraternity listening to that, enough number not applied. I am again giving example of shortage of forensic fraternity. That is why there is need for increasing seat. If you have not started PG forensic medicine, please start PG seat, or ask them, motivate them to apply for those permanent posts for getting employment as a specialist at district level. Vision of the future. These are some of the findings from the Law Commission report. I am just passing on because time is not there. So everything that depends upon these factors, because the government is working on the good governance. Here our role is very important. So participatory democracy is important, and that is not possible without qualified, trained, educated forensic medicine expert, especially in case of medical legal work. This is recent observation of Allopathic High Court and finally by Supreme Court. You remember that case of Hathras, where rape and murder of a female done, and the body was cremated in night without following any protocol. A court has given importance, again realize the importance of Article 21, dignity of dead body, including post-mortem procedure. So these are some of the changes after that direction of Honorable Supreme Court. This is one of the advertisement where now they included forensic MD forensic medicine as eligibility criteria to join as joint director in forensic science laboratory, another career opportunity for new generation. These are some of the observations regarding viscera importance and importance of that van for movement of dead body from mortuary to the crematorium. So these are again, time is the constant. I will not defy that. I have already discussed on this question. Who will do, preferably by forensic medicine expert. Till that, trained manpower, our help. This is another judgment of the Honorable Supreme Court in 1989. Again, I am emphasizing Supreme Court judgment in 1989 answering your question. Who will do the post-mortem examination? They quoted Lady Hardinge Medical College and AIIMS Delhi. Practice adopted by them. 2 notifications found mentioned in this court judgment. One is 16th May 1969, another 6th January 1988. And even they mentioned, because the complaint was by the victim side, the post-mortem done by junior doctors who are not trained. And court said that senior doctors, faculty must be there, or at least they should countersign post-mortem report. This is for new generation. You should be protected by your senior with their experience, with their patronage. This is the Honorable Supreme Court judgment, which is a law applicable throughout the India. A court mentioned if more than one person conducted the post-mortem examination, it is desirable. They would use the word desirable. Why? Because there is a shortage of forensic expert throughout the India, and this judgment is applicable. That is why I use the word desirable, not mandatory. But if available, it is mandatory. It should be signed by the post-mortem, those who are doing medical officer and one of the faculty part of that team. And they recommended that AIIMS pro pharma can be used throughout the country for this. And they assigned this responsibility to then Medical Council of India. Now it is National Medical Commission to take care of this judgment to make changes. This is the reference from where I have took this. Again, just passing on some of my suggestion. I will share this presentation. Another judgment of Supreme Court, again ongoing, roadmap for speedy investigation and monitoring mechanism by investigating agencies. Upgrade infrastructure in government medical college to deal with forensic science investigation. Supreme Court judgment, law of the land for country. You can take advantage of that this judgment to upgrade your department. These are the questions which posed by the court and answered by the court. Again mentioned importance of Article 21, which is fundamental right. This is a fact mentioned in this judgment also. What is the situation throughout India of forensic science laboratories, their manpower? And in this recent judgment, court mentioned 1980 judgment of the Supreme Court. In 40 years back, they recommended for this amendment for improvement of Central Forensic Science Laboratory, Forensic Science Laboratory, Forensic Medicine Fraternity, etc., etc. But no one listened. That is why we are crying again and again. Court defined your subject. Court defined your subject and emphasize the importance of your subject, not only for the teaching purpose, but for the serving humanity in the form of quality investigation, search for the truth, justice delivery, which is the ultimate aim of any criminal justice system. So those who are interested, they take, I have made one strategy. I have made this petition, online petition, change.org on the same question. Almost 1 year has elapsed. Important, this my words. एक साल में, 1 year में, on and अभी देखा, I have just again recirculated that petition. Not even 500 fraternity or persons signed this petition. We are having more than 1500 IFM life member and more than that forensic fraternity. If you are not signing this petition, the moment it crosses 500, it will be taken as recommendatory PIL to the concerned authority. So I am requesting, please sign this petition, available online on this link. And we are planning another with other associations other than forensic medicine fraternity like IMA, Institute of Medicine and Law, to again organize 5 webinars in zones and then 2 physical meetings at the Mumbai and Delhi, and prepare a white paper on this amendment with the help of judges, advocates, and forensic fraternity to submit this recommendation for enactment of Act. So again, these questions I have already discussed. I'm not. This is the ray of hope. Recently, Ministry of Home, Government of India circulated this request for suggestion, and they formed a 5-member committee under the chairmanship of Vice Chancellor, National Law University, Delhi, to give your suggestion for amendment in CrPC, Indian Evidence Act, and IPC. This is our ray of hope. Another important budget allocation in this recent 2022 budget, they allocated for digital criminal justice system, where at your department you can be part of through video conferencing and recording your statement as an expert. Lot of work has been done by Punjab and Haryana High Court. I have that figure with me. Ki kitna how much money we can save, how much time we can save by moving and TADA, etc., etc. Now they use the word for this upliftment, 300 crore allocated for e-courts, e-police and e-forensic, where we are part of that. So there is hope, there is no, and this is again newspaper item of 19th February. To date is 23rd February. 4 साल में डिजिटल होगी आपराधिक न्याय प्रणाली. If there is a political will, if we are guiding them, if we are raising our voice, not for our benefit, but a benefit of our fraternity, our young generation, for the victim, for the innocent accused, our voice must be heard. Thank you very much.
Thank you, sir. Dr. Sarvesh could not join us now because he has a meeting to be attending right now. But we do have a few questions. Sir, the time is limited, so quick questions for you, sir. Dr. George has given a lot of inputs in here, and he has indeed recommended, apart from the Coroner's Act of US, the Singapore Act and the Victorians Act in Australia are also efficient enough and can be looked upon. So those
Can I directly ask?
Yes, sir.
Dr. Yadav, I think you should actually convince the courts that UK is not the model to go. Because in the early 2000s, I was actually doing an autopsy in Sheffield, and I was told, histo rakhne ki zarurat nahi hai. Coroner will not approve. I said, toxicology, no need. Then I found DVT, so I was going to dissect, the traditional method of slitting the calf to expose the calf muscle, section it for, They said, no, please don't do that. The coroner will not approve mutilation of the body. You can make a slight 2-3 centimeter slit on the side, probe inside. If you get clots, you got it. Otherwise, of course, it must have come from down below. This is the coroner system you're going to recommend? We shouldn't be doing so.
No, we are not recommending coroner system.
Yeah.
We are asking for amendment in 174 CrPC.
Yeah, I mean, if you want to look at any system...
It is not the name which matters. It is the content of that document which matters.
See, the content actually...
And I found this Singapore that act which you are using is very good.
No, but then you see, then what will happen is in the judicial system, in the coroner, in the inquiry system, the inquest system, the focus will shift from finding fault to who did, how did, when did, who died, how died, when died, where died. Just these 4 questions. So the verdict is also in the same manner. For instance, they will not say homicide caused by another, and they don't easily go to accident and this, and causation is not gone into, So there'll be a shift. So is the whole country ready to shift in that direction is another issue you have to think of. Okay, that's all I had.
Thank you, sir. Thank you.
Thanks, Dr. Paul.
Yes.
Will you please submit in writing your suggestion to IFM?
I'll do that. Definitely.
Thank you, sir. Thank you, sir.
Member bhi to hu na bhai.
Yeah. That is why I'm asking.
So then we
Any
have
other questions?
yes, sir. 3 more we have. Quick question, sir. One from Dr. Flemington. He has asked what type of paper court wants PM reports to be given in, sir. From Flemington, sir, am I getting it correct?
Initially they are asking for the good quality paper.
Okay.
Because the paper used in UP at least a very thin paper which will be destroyed if suppose a little water or moisture is there in the atmosphere. That will, the whole report is destroyed. Now we are not talking about the paper. We are talking about the paperless. Now we are moving toward digital India, which can be needing less space, which can be transmitted through any part of the world or court through that digital media. That is why e-court, e-police and e-forensic. Integration of all these. And the IT sector, whenever they found anything, they concentrate, that system definitely going to improve. Whole banking system is improved.
Yes,
so now, and when many states have taken lead, Punjab and Haryana High Court, everything is now digitalized. But PGI Chandigarh has done a good study on that.
Yes, sir. Even
And video
I give
conferencing is
someone from
the
here.
now reality in many states also.
Yeah, we give someone in Haryana from here, from Puducherry.
Yeah,
So
yeah.
that's a good thing. And end-to-end encryption of the reports are on process. That's what we heard also. So another question from Dr.
Okay,
Chandra.
on this point. On this point, there's a little issue. We are doing digital work and we find we make more mistakes. We have to keep issuing corrigendums.
Copy paste.
So everything has advantage and disadvantage.
Dr. Chandrakant, he has asked that yesterday I attended a warrant summon. The PP was asking me, did I ask for, did the person who attended the court ask for inquest report before conducting the post-mortem? Can anyone throw some light on this?
Yeah, it is your right. It is your right. You should take all the documents, including medical record. You can ask in writing. If you are satisfied that that will going to help to come to the conclusion of all the answer, including cause of death. It is your right.
Thank you, sir.
That is part of Panchnama.
Panchnama, yeah.
Or whatever the word used in your state or territory.
And one last question we have from Dr. Mohammed Ziaduddin. In some broader cases where the doctor is not in the position to issue the cause of death certificate, the doctor issues the MLC and informs the police for further legal proceedings. In many such cases where patients have history of chronic illness like carcinoma or any other, on request of the relatives of patient, police gives requisition to the doctor for disposing without the post-mortem examination in such cases and hands over the body to the relatives without post-mortem examination. It is being done under CrPC 174. Now, in this case, cause of death is not issued. What would happen to the data of death report submitted to the Register of Birth and Death in such cases? What would be included as cause of death by the registrar in such cases?
I think very relevant question, very practical question faced by most of the forensic fraternity, and we have taken care of that because there is shortage of forensic medicine expert. So what is the stopgap arrangement? Stopgap arrangement to avoid unnecessary postmortem. और बहुत से judgment में court has mentioned this word कि if there is no dispute, why doctor is called for that? Their affidavit is more than enough. So similarly, MCCD scheme, if you remember, Medical Certification of Cause of Death scheme 1999 is applicable in our India, but nobody is aware of that, in which there is a provision. Because police person are lay persons. They rely on you or to be on the safer side. They just ask you when you inform about the broad death case. But it is the doctor who will give, no, I am satisfied. And in that scheme, it is mentioned, any doctor who attended the disease in last 7 days can issue a death certificate. Issue is where there is a greed, where there is a dispute. Say, for example, property dispute between two sons or son and daughter, and father died, and father was residing with one of them. Another was making allegation that इसने सारी property that bill is taken in his or her favor, and I have been denied, and he has killed him. In spite of doctors, everything you have to answer to that dispute, and that is only possible through. So in that case, opinion of other doctor, even hospital administrator, EMO, emergency medical officer, that can be taken care. Take in writing from the relative or whoever raising the dispute if they don't want any medical legal work, and if they are, because that is part of, that should be part of amendment. Say of the victim family whether they want postmortem or not. If there is no dispute, then why there is a need of burdening already shortage of forensic medicine with the unnecessary postmortem. Say for example in accident cases, इतने accident cases हो रहे हैं, expressway बन रहे हैं, and where everybody is satisfied patient died due to accident. What is the need for that cause of death, whether it is accidental or natural? It is proved. Evidence are there, CCTV cameras are there at roadside. So these are some of the important issues which should be discussed and part of the recommendation.
Using resources efficiently. Thank you, sir. Thank you so much for that wonderful talk. Sampath sir, any last remarks?
Yes, sir. Thank you, Dr. Mukesh, for your excellent enlightenment from the various agencies, your amendments from various agencies, and updating all that court cases, so that they'll be enlightened. In fact, the next question was supposed to be from George Paul, to be handed over whom to hand over the body. When there's a dispute, we are not supposed to hand over the body to anybody. We are supposed to hand over to the police. Police will take the call. And same thing in the other case, whether we can make it a non-medical legal case. It is the doctor's decision. When the cause of death is not known, we are not supposed to issue a death certificate, and autopsy has to be done. Once it goes to the police, police decides whether autopsy has to be done or not. And in that case, we'll have to obey the police. Thank you, Dr. Mukesh Yadav, for sparing your time. As earlier told, in spite of your organizing as an organizing capacity chairman, still you found time to prepare and present and enlighten everyone on this. All further questions will be addressed to you to your mail, and we'll be pleased to have your answers also. Thank you very much.
Thank you, sir. Thank you.
You can continue.
Thank you, sir. Thank you for the wonderful session. Thank you, Dr. Sampath, for chairing the session also. And the few of the bills and documents sir recommended have been posted in your chat box. The PIL, which sir recommended, has also been posted in chat box. The sir is lagging by 25 votes right now. So I hope by the end of the conference, sir, you can start with it. All the best, sir, for that. So moving ahead, we will move to our next session. The next session, to look into the international standards, that is what we are planning, right? So move ahead and go ahead with the international standard. We have Dr. O.P. Murthy to talk about raising the Indian standard equivalent to international forensic pathologist. What